Just bang your gavel on the top.
Please come to order. We're ready to start the afternoon session. Will Mr. J.R. Matthews, Vice Chairman of Sycuan Tribe of Oklahoma and Treasurer of the National Indian Gaming Association, please come forward?
Thank you, Madam Chairman.
Good afternoon.
Oh, good afternoon. I'm in Oklahoma, I'm sorry. Would you like me to just begin? Mm-hmm. Okay. I was asked to come and testify from a historical perspective, also on the federal level with the tribes and ourselves. I've been involved with gaming since 1984. It was interesting, I was just talking with my chairman, who is going to testify later today, going back through all of my documents, because we're trying to gather up our own historical documents. I found our original bingo gaming ordinance that we wrote in 1982, of which my uncle was one of the members of the commission, along with several other people. Our current regulator's father was on that commission, as was two former chairmen of our tribe. So we have been regulating bingo and other forms of gaming since 1982. We've been actively involved in this. It's something that we do on a regular basis. So when IGRA came along, we had to change. We had to adapt, and we had to create a new gaming ordinance, which we did, submitted, and was approved. We've been dealing with the federal government for many, many years, and some commissions have been favorable, some have not. The current one, of course, has taken upon themselves to be overly ambitious, in my opinion. Several things I would like to ask if I could submit to the record. In January of this year, I wrote a letter, or an opinion page for the Indian Gaming magazine, which was about Class II gaming on the floor and how important it is to tribes across the country. Class II gaming is the basis of Indian gaming. It is the basis of IGRA. Because before that, there was no Class II. You know, today we have a lot of people talking about Class II gaming. Well, that is particular to tribes, particular to us. And it's important to us because without Class II, we have no leverage for Class III compacts. We now in Oklahoma have a Class III compact because we had Class II games that were fast, fun, and profitable. And therefore, Oklahoma stepped up to the plate and made a compact with us. Today, we still have Class II games on every one of our floors. We are participating at every level with Class II games. And it's important that we continue this support of the manufacturers of Class II, because down the road, we will need them. And in my article, that's what I was talking about. I was talking to tribal leaders, to gaming commissioners, to operators about Class II on your gaming floor. Several years ago, I heard a gentleman from NASA speak, and he talked about the space program. He was asked if we could land a man on the moon, and he said yes, but it would take 6 years. When asked why, it was because they didn't have the infrastructure to do that today. They would have to go back to rebuild all of the elements that it would take to put a man on the moon. That's the same thing with Class II. If we drive Class II out of the market, if all the Class II manufacturers, which they said they would do, and that is in testimony, which I'd also like to submit, This is from the Class 2 hearings that the NIGC held on September 19th, 2006. And the Class 2 manufacturers stated that if the regulations that they were putting forth were put in place, they would leave the Class 2 arena. And if that happens, then we as tribes are going to be the less of that, because we will not have a game that we can participate in on any level other than a Class 3 and letting the states be the primary regulators, of which they are not. We are the primary regulators. And so it's important. So I'd like to be able to present this as part of my testimony. Okay. So in response to, I'm sorry, I don't have a case. So in response to my article, the chairman of the NIGC chose to write a letter, of which he sent to me, and I would like to give this to you also, that was a rebuttal to my article, because he missed the point. My point was not about the NIGC. My point was to the regulators, to the tribal administrators, to the tribal chairman, and to the operators of how important it was to keep Class 2 on the floor. That's why I ended the statement. If you don't have Class 2 on your floor, why not? Because we need to protect our manufacturers. We need to protect our games, and they are our games. They're no one else's. They are the tribes. And we are the ones that should regulate them. We are the ones that should take care of them. And so I'd like to give this, because this is the letter, and you can see how Indian Gaming Magazine wouldn't print a vicious attack upon an individual, of which Phil Hogan did, and reduced it to this article. But even with this article, you know, one of the issues that we have within this is that he keeps saying that he needs to create a brighter line, a bright line, and he keeps going back and forth on this. But in this article, I'd like to read to you where he says, although a stated goal of our original rulemaking process was to draw a brighter line to distinguish the computers and electronic and technological age used in Class 2 bingo from Class 3 slot machines of any other kind. He acknowledges by this statement that there already is a bright line between Class 2 and Class 3. He just wants to make it brighter. That is his desire, not mine, not anyone else in Indian country. So I'd like to submit these also as part of my testimony. Now let's start talking about the expansive view of the NIGC and how they have a view of their regulatory powers and how they believe that, that they are becoming the primary regulators and not the tribal people. Because it is that view of Indian gaming that they have focused on, and they're wrong. And we have to be able to do these things, and that's why one of the reasons that I came was because I'm very proud of the Sycuan tribe for doing this and stepping up and making this type of an effort to be able to put a record out here for all of us about Class 2 gaming. And so I just have a few more comments that if the NIGC can put forth a view that the game of bingo can only be played if players in the game must take multiple actions. This is an argument that distinguishes the game of bingo from a slot machine. That's what they're saying. That's not an argument that we need the NIGC involved in. That's an argument for the tribes and the states, or just the tribes themselves. These are the things that we have to be concerned with as our regulators. You know, we at Quapaw Tribe of Oklahoma, we have a strong regulatory body. They're the ones that we have to submit everything to. They are the ones who control our gaming ordinance. And they're the ones that are the primary regulators for us as operators, as for the tribe. You know, we don't depend upon the NIGC to come in and tell us how to run our games. And that's the way it should be across this country. One of the other things that I would like to say before I close is that one of the things that we have to think about as tribes, as tribal regulators, is that we need to consider an approach of what Class 2 is. And that is, let's go back and look at what IGRA says. What is the definition of Class 2 gaming? And then look at the NIGC's regulations dealing with electronic, computer, and other technological aids. If we do that, we can define what Class 2 is. And we already have it in the record from those two issues. And I think that's where we need to look and go. But the NIGC has overstepped their bounds. They have pursued a false sense of urgency to create this new class of regulations upon all of the tribes. Thank you.
Thank you. Are there any questions for Vice Chairman Matthews?
Question.
Mr. Foreman?
Vice Chairman Matthews, what's your thought as to the NIGC or the Bill Hogan's specifics motivation for wanting to draw this brighter line? Is it something that is within him? Is it something that is where he is responding to perceived external pressures? What do you think is really happening?
I wish I had that answer. I really do, because that's a question that we've asked many times. You know, what is the driving force? You know, we worked, when I say we, there were several people that got together with the technical work group for 18 months and worked very diligently on coming up with a technical standards and how to apply it for Class II gaming. He had a chance at that moment to come away with a slight victory, because it was a document that not everyone was happy with, but everyone agreed upon. And by doing that, had he just taken that and adopted it, he would have at least led to some regulations that everyone could have lived with. But he didn't do that. He took it and changed it. And then he wanted to create mix, which went beyond beyond the scope, even beyond what he had stated as his goal. So why he does that, I have no idea, other than the fact I have to believe that it comes from his sense of duty to the Department of Justice, because he was in DOJ for so long, and I think he owes it to his federal family brothers over there. And that's the only thing I can think of, because other than that, I can't imagine anyone wanting to have their career known as the one who destroyed a class of gaming.
Thank you.
I have a couple of questions, JR. Given what you said about the role of tribal regulators in relationship to Class II in particular, but certainly all of tribal gaming, what would be your view in an ideal world, or in a world maybe post-Chairman Hogan, of the role of federal government? Well, what is the role of the federal government in the regulation of Class II gaming, as you see it?
Well, I think if they set the commission up properly and would support the tribes, because not all tribes need regulations as from the federal level. What they need to do is to be able to go in and do what they're supposed to do, and that's give technical assistance. They should be able to go to a tribe who doesn't have the money, who doesn't have the expertise, and help them develop their regulations, their regulatory body, to do the things that they need to do. But we've been in this business. You know, there's very few tribes out there that are still in the infancy of their gaming. There are a few still, and those that need help should be able to get help. But right now, we've got the NTGAR, we've got the Oklahoma Tribal Regulators Association, we've got all of these other regulators that have come together, that are working together across Indian country to make sure that this game is safe, both for the tribes and for the patrons. We're not wanting to subvert anything from the tribal point of view. We want to make this a safe and effective game. They should be our partners in doing this. How can we best do this but move this wagon forward? You know, because what we have to think about is gaming is only one economic drive within the Indian tribes. Every tribe and every nation has to be able to expand beyond gaming. And that gaming revenue, if it's diminished, and one time when I sat in front of the chairman, we were in Oklahoma at one of our consultations, and we started talking about these regulations. This was 3 years ago. And you know how Phil loves to give his little eloquent speeches and similes and on and on and on. So I brought in some pennies. And I said, you know, Phil, I said, these are the ones that we currently have. And I set up 30 pennies. I said, this is what we are currently making. But with your regulations, and I took it down to 9 pennies. I said, this is what we'll be able to produce revenue-wise. He reached over and pulled off 8 of the 9 pennies and left one on the table and said, yeah, but this is what you had before IGRA. That was his whole idea about what we were doing. Instead of saying, well, here, let's take some of these and build this 9 cents up. He has no intention of promoting Indian gaming to move forward to become more profitable.
Well, thank you for that. There's another part of that, I guess, that, as you know, I was in the room when that happened.
Yes, you happen to be chief of staff at that
Yeah, I
time.
happened to
know.
be then. You have to remind me of that. But looking at the mission of the NIGC in relation again to the mission and the duties of tribal regulators, such as Sycuan. Sycuan has adopted a fairly extensive set of regulations of their own. And in your view, what should be the relationship or the role or the impact of tribal rules and regulations in relationship to the NIGC?
Well, that's a very difficult question in a lot of ways. I can't answer for all tribes. I can only answer for mine. Sycuan has to answer for theirs. But I think together we can come up with a base for regulations. We can come up with a baseline for all of our differences that we have. But we can come up with what this industry is, what it needs. Each tribe, though, must take it upon themselves to regulate themselves, to develop their own regulations, and to enforce those regulations. The extent of those enforcements should be at the behest of each tribal regulatory bodies. We can't put what happens in California upon what happens in Oklahoma. We have totally different circumstances. So it doesn't help us to do that. And I think that's one of the problems that we have with the NIGC is that they're not looking at tribes individually. They're looking at us as a group, and we are not one group of people. The fact that the Quapaw tribe, in Oklahoma doesn't even respond to the other tribes in Oklahoma as far as culture, language, assimilation, any of those other things. So why would we necessarily be in association with them in line with their gaming? Because we want to regulate ourselves. And therefore, I don't think that you can have a complete set for all of them. But what the Sycuan are doing here, I think, gives us a base of what we can take away and use with ourselves. And I think every tribe has that right and opportunity.
I guess just one final question, at least for me anyway. In relationship to the Quapaw's relationship with the state of Oklahoma when it comes to compacted game versus Class 2 games, if you can give us just a little, I know Chairman Berry's going to come out shortly and talk a little bit about this too, but if you could, from your perspective, maybe tell us how that relationship is working, and both in terms of who decides what's Class 2 in Oklahoma and who doesn't, and to the extent there have been any differences, how they've been resolved.
The state of Oklahoma is an infant when it comes to gaming. They have a lot of people in there who don't understand this business, let alone Class 2. So what we have done is we've taken it upon ourselves to try and train and teach them. When we have a promotion, when we have something that we want to do at our casino, we take it to our liaison to the SCA. And we explain to them why we do what we do. One of the things that we did, and I'll just give you an example, is we have what's called a no ante. Because in Oklahoma we play Class 2 blackjack, where they have to ante up for every hand that is dealt. 25 cents, 50 cents, you set your own regulatory limit. So we went to them with the idea that instead of taking the players pool, which is what the loss is from the table games, and then giving it back to the players through prizes, drawings, and other types of things, we took that and bought their antes. It was the way we kept our records for the state, that we did not take that daily prize away from or that daily pool away from their monies. So that in effect, what happened was, by doing that, we had more play, therefore the bottom line was greater for the state. But when we showed them how we accounted for all of that, and we took them through our entire process, they were very pleased and gave us a letter, said that this was an approved promotion, that they had no problem with. So we work very well with them. You know, they don't come in and get bent out of shape and say, you know, you're a notice of violation, or they don't. They talk to us. They come to us and they announce when they're coming to our facilities, and they want to, you know, be informed. And we sit down and work with them as partners in our compact. And we show them how many Class 2 games we have. We show them why they're Class 2, and then we show them why they're Class 3. I have many state senators and representatives that come to our facility because they know that we take our time to explain to them what it is. I will take any state representative and take them in and set them down in front of a Class 2 machine, and I'll let them play. I'll say, here, just play. And I'll say, here we go. Now, and I cover up the display. And I said, now play it. And he plays, and I said, did you win or lose? He goes, well, it shows I won. I said, why? I said, here's the bingo card. Here's the pattern. And I show him everything about the game of why he played a bingo game. He goes, oh, okay. So we take him over to a Class 3 game, set him down in front of that, let him play. Once they understand the difference between those two games, now they've got a concept of what they're talking about when they go back to the state of Oklahoma. So when they're in their sessions and talking about it, they understand the fundamental differences between a Class 2 bingo game and a Class 3 slot machine. And it is with that we work very diligently with the state of Oklahoma to keep them updated, to keep them informed, and know what we do every day. And they're very pleased, as are we, with everything that we do with them.
Any other questions?
Yes, I have a couple. First of all, does your tribe play one-touch or two-touch, or both?
Both.
Both. And has the state ever made an issue about the one-touch games?
No.
Has the NIGC given you any grief about the one-touch games?
Given us? No.
Yeah. Okay.
Have they said anything to others? Yes.
Do you have a sense what the difference in, if any, in productivity is between a one-touch and a two-touch game? And if so, do you have a theory as to why that difference exists?
Well, I have a theory, but, you know, I mean, it's time on the machine, time versus spins. But that minutia is something that we don't really need to worry about. My whole concern, and where I come from, I've spoken on this for many, many years now, is that we can show you if it's a game of bingo. IGRA doesn't say anything about the play of it other than if it's a game of bingo. And I mean, that's what the definitions are. And we know by the technical specs within that game, is it a game of bingo? Are there people playing? I mean, there's a whole checklist of things that you do to, is it a game of bingo versus a slot machine? Or in Oklahoma, what do we call those things, Jess? Covered games. That's a technical term. So we do know the difference. And getting into the one-touch versus two-touch, that's not something I even want to talk about, because what I want to talk about, is it a game of bingo or is it not a game of bingo?
Likewise. Thank you.
Any other questions?
Yes, Madam Chair. Mr. Matthews, you alluded earlier in your testimony to the famous 2006 hearing with the National Indian Gaming Commission, and even offered us a disc recounting that event. The commission would be most interested in your unique historical experience. If you could talk just a little bit about the package of regulations that Indian country was confronted with. We don't want to forget about the fact that not only were there technical standards to Class 2 gaming promulgated by the National Indian Gaming Commission, but at that time, they were also had published classification definitions for Class 2 gaming and definitional regulations. Could you share with us a little bit about where those regulations went? How come Indian country was able to coalesce together and convince the National Indian Gaming Commission to not publish those onerous regulations as well?
Wow. It's always been an interesting thing to see the current National Indian Gaming Commission and their procedures, that they seem to time the publication of a regulation around a holiday, around an election, around other events that will take away or not give you the time to respond to these regulations. They didn't just come down and try to put forth a technical standards regulation. They came in and dropped 4 regulations at once. I don't remember exactly what it was. You were chief of staff. What did he say about it wasn't a cacophony of, or it was a cacophony of dissidents. It wasn't a cacophony of dissidents. It was people standing up for what was right, because he was wrong in doing what he did and how he did it. And he has done that for the last 3 years. And since his time ran out, he has gotten worse and worse and worse. I mean, the man's been in it for over 5.5 years, 7 years, 7th year. I mean, come on. You know, there's a reason we want these guys to change. But the fact is, he always took a look at the calendars before he would publish any regulation, before he put forth any sort of a memorandum or an understanding of any kind. And I can't ask Joe to disclose anything because of his history, but it seems very odd that those regulations, the 4 of them, plus the others that have come forth since then, all come at circuitous times.
Any other questions?
From the back row.
JR, my name's Jess Green. You know who I am. I want to be sure that we document your bias. You handed out little bitty buttons 2 years ago after the NIGA meeting that said, "You people, the downtrodden." I want you to explain why you did that.
Okay, I'm not really biased. We were at a meeting, and Chairman Stevens of the National Gaming Association and I were speaking, and many others with Phil, about all of this process, about the hearings, about the regulations, and on and on. Phil made the statement at that time. He said, "Well, I understand, you know, about you people and how downtrodden you are." I couldn't believe what I had just heard, so I wrote down "you people," and I underlined it and was looking at it. Tracy Stevens got up from across the room, ran around, came over to me, and she goes, "Did you just write down "you people"?" And I said, "Can you believe he said that?" And so the following couple weeks later at Great Plains, I had made some buttons that said, "I am one of you people, the downtrodden," because that's who he was speaking about, was us as tribes, which is interesting because I always thought that he was of the Lakota Sioux. Maybe I was wrong.
Your articles have been particularly critical of him of late. Is that not that's also correct, is it?
Yes.
And the National Indian Gaming Association has recently passed a resolution concerning Chairman Hogan, and would you describe for us what's in that resolution?
That resolution was asking the Obama administration to appoint a new chairman and a new commissioner as quickly and as effectively as possible. Kurt Luger made the motion. I seconded, asking that the motioner would include the words to ask for the resignation of the chairman effective immediately. I have no qualms in asking for this man's resignation because he is injuring Indian country.
Does your personal issues with Chairman Hogan affect the testimony you give in regard to the truthfulness and what you believe to be the truthfulness of what you've given us here today?
No.
Would it be fair to characterize that what you're doing is simply asking for a replacement because you'd like to have somebody new to joust with?
Doesn't matter who it is, I'm going to do that. You know me. I've been doing it since Tony Hope days.
Thank you.
Yeah, Vice Chairman Matthews, I have one question. You alluded a minute ago to other regulations that the NIGC has been in the process of promulgating over these last couple of years. And I was wondering if maybe you had some thoughts in terms of, in context, what they've done with Class 2 in the context of the other regulations that they've issued, and whether that may reflect a particular approach to Indian gaming, and your feelings about that.
Could you restate the question?
Sure. You alluded to the fact that the NIGC has also issued other regulations, the facility license regulations, amendments to the mixed regulations, and from your perspective, is there a similarity in approach to tribes and Indian gaming to what the NIGC is doing with Class 2 compared to what they're doing with these other regulations?
You mean overreaching and overbearing? I would say yes. We tend to look at what the NIGC does, and they have stopped focusing on gaming, and now they're looking at everything beyond those reaches, because when he got told that he was not the primary regulator for Class 3, he turned his eyes upon Class 2 and has viciously attacked it.
Any other questions? Thank you, Vice Chairman. Chairman Matthews.
Thank you very much, Madam.
Our first panel this afternoon is comprised of tribal leaders. Chairman James Still, Confederated Salish and Kootenai Tribes. Chairman John Berry, Chairman of Quapaw Tribe of Oklahoma. Would you please come forward? Chief Tom Gamble's plane was delayed. We will hear from him later on in the hearing. And President Joshua Weston is unable to be here today. Welcome. Chairman Still, we'll begin with you.
Good afternoon, Madam Chair and members of the Sycuan Gaming Commission. Asselchat, Kisukyukit, greetings in our two tribal languages. I have a written testimony which I will read in part, and then I have some other things that I would add. So the written testimony will have it emailed to you and submit it that way if that's all right, my written testimony. But I'm going to read from my written testimony, and then I'm going to throw some other thoughts in that aren't included here. My name is James Steele Jr. I'm the chairman of the Confederated Salish and Kootenai Tribes of Montana. I also serve as the chairman of the Montana-Wyoming Tribal Leaders Council. And my comments today are on behalf of my tribe. The Confederated Salish and Kootenai Tribes are comprised of the Bitterroot Salish, the Pend Oreille, and the Kootenai Tribes residing on the Flathead Indian Reservation. The Flathead Reservation is approximately 1.3 million acres in northwest Montana and is our home now, but our ancestors lived in a territory known as Western Montana, parts of Idaho, British Columbia, Wyoming, and parts of Washington. This Aboriginal territory exceeded 20 million acres at the time of the 1855 Hellgate Treaty. The vision of the Confederated Salish and Kootenai Tribes is the traditional values that have served our people in the past and are embedded in many ways that have served our people and our people's best interests. The mission of the Confederated Salish and Kootenai Tribes is to adopt traditional principles and values in all facets of tribal operations and services. We have and will invest in our people in a manner that ensures our ability to become a completely self-sufficient society and economy. In moving forward to operate a Class 2 gaming facility on a reservation, we relied on the premise and purpose of the Indian Gaming Regulatory Act, which was to promote tribal economic development, self-sufficiency, and strong tribal governments. Because of the unattractive compacts being offered by the state of Montana, we chose to eliminate Class 3 on the reservation by not entering into a compact with the state, and instead we chose to operate Class 2 gaming, which in turn has put us in the driver's seat. Just a little background in terms of our Class 2 and 3 operations. Number one, gaming is not, it's more of a side issue, really, in a sense, in terms of our economic development. We have not been a very large gaming tribe. Our primary majority of our income comes from timber revenue and the Kerr hydroelectric facility, which is one of the largest hydroelectric power generators in Montana. And in 2015, we will be able to purchase that. It's a $1 billion asset that we will potentially be able to purchase for nearly $40 to $50 million in 2015. In terms of gaming in Montana is, in my opinion, not one of the best places to have gaming for an Indian tribe. We are now one of 2 tribes in Montana that are exclusively Class 2. If you put both of our operations together, the Blackfeet Nation and Flathead together, you know, we might have 1,000 machines maybe, or 1,500 between the 2 of us. The Class 3 games in Montana are on every corner, every street corner, every mom and pop has what they call Lucky Lils, or a little bar that has a few machines in it. And so the market is saturated with Class 3 machines. The payout maximum for those machines is $800. In 2006, we started on a 2-track process. Our Class 3 compact was about to end in November of 2006. Our tribes decided to do 2 things. 1, continue with Class 3 negotiations, and 2, start our Class 2 operation simultaneously. The intent being that we would ask for the maximum allowable under Montana state law, which we believe was, we wanted to have the ability to determine the number of machines. We wanted to be able to have the maximum payout that we felt was appropriate, and we wanted to have determination over the wager. And on our reservation, we were in a weird but unique situation that I know of. We had state-regulated operations that were not regulated by the tribes. So we basically had non-tribal operators on our reservation utilizing Class 3. And so there was nearly, for us, $20 million of gross gaming activity on our reservation occurring, but of that we were maybe getting 1 or 2 million. And so when we entered the Class 3 gaming issue, and I'm sorry if I'm getting off track, I don't know if this is helpful or not, but it's just some things that aren't in my testimony. But we went down a parallel track. The governor of the state of Montana, who I just stay off of what I personally think about, but basically threatened the tribes, and if you don't sign this Class 3 gaming compact, you know, your re-election is in question. So that was to me, I guess. So based on that, our tribes and our tribal council enacted our proposal on Class 3. He didn't sign it, it failed. So now we're strictly Class 2. All of the Class 3 operators are no longer operating on our reservation. The other thing I'd like to add is that in terms of Chairman Hogan, I will express my bias that I think the man needs to resign, and he needs to resign yesterday, and he needs to resign today, and he needs to resign soon. And I believe that strongly, and I've said that in letters, and I've said that to our council. The reason I say that is because for us, Class 2 is one more facet of our portfolio of income. And I think that Class 2 has been a very important thing for Flathead and Salish Kootenai, is that we have the ability to regulate it. We don't have to be involved with the state of Montana, which is great. I mean, and it's our decision. It should be between us and the federal government. It shouldn't be between the state of Montana and our tribes. And so for us, it was a sovereignty issue, but it was also an economic diversity issue. Back to the other thing is that we filed with one of two tribes, Santa Rosa and our tribes filed a lawsuit against the NIGC, basically challenging the process that they used to come up with some of these variety of rules and regulations. And I'm sorry I don't know the exact terms, but in doing that, filing that lawsuit, it was to bring attention to the fact that we believed that the NIGC should comply with the Federal Advisory Committee Act, which basically says you have to have your meetings published in the Federal Register. They weren't doing that. And I appreciate the gentleman before. They would just have a gathering of tribal leaders at a meeting, and then, by the way, we're having a hearing, or we're having some testimony. Come on in. That's not proper procedure. Needed to take minutes. Needed to record the proceedings. We asked the NIGC to come to Flathead, and we had it in a regular council session. We had it in somewhat of this kind of a scenario where it was on the record and that kind of a thing. And I believe, in my opinion, our Santa Rosa and our tribes filing that lawsuit stalled it out a little bit. And if that's what to bring attention to at the time, an important issue, I think we were successful. With that, I have a majority of my written testimony that I will submit into the record, if that's okay, Madam Chair. And I'm done, and I appreciate the opportunity to speak before you all. Thank you.
Thank you, Chairman Still. Chairman Barry.
Thank you very much, Madam Chairperson Tucker. I would like to thank the Sycuan Commission for inviting me to this day, and I'd like to congratulate Daniel Tucker on such a beautiful, and the tribe on such a beautiful resort. It's a kind of place that the Quapaw tribe is just striving to grow up to be like, and we appreciate the opportunity to come here. A little bit about myself and about the Quapaw tribe. I've been the chairman of the Quapaw Tribal Business Committee for 7 years. A fifth-generation rancher on my grandmother's allotment in Osage County. I'm also a member of the Osage tribe. Some of my Indian affairs background, I worked for 5 years for the Department of the Interior as a consultant while I was chairman, trying to develop an implementation plan to improve tribal and trust services within the Department of the Interior that ultimately went nowhere, as those things typically go. I was a one-time candidate with Phil Hogan for the Assistant Secretary of Indian Affairs, and I'm currently a presidential appointee to the Advisory Council on Historic Preservation. So I have I have kind of a common thread, being a Republican, that I've dealt with Mr. Hogan for a number of years, and I think I have some comments about sort of what the issues that I see with his process. The Quapaw tribe we're the indigenous people of eastern Arkansas. We were called the downstream people of the Ogahpa people. And like many tribes, we were forced to the great Indian Gulag in Oklahoma in the middle 1800s. And for a number of years, we struggled and starved and really struggled to survive. Before the Louisiana Purchase, there was nearly 200,000 Quapaws. Within 10 years, we were down to nearly less than 500. So the Quapaws have a long history of difficulty, but also we're survivors and we're fighters, and we see ourselves as descendants of people who were survivors. The Quapaw tribe currently, our homeland is in Ottawa County, Oklahoma. It's in northeastern Oklahoma. It has been traditionally the most economically depressed county in the state. Unlike our brothers and sisters, the Salish Kootenai, who live in Xanadu, we live in a Superfund site. We have 40 square miles of scarred land that was the result of horrible federal management of Indian mining and mining operations that left the Quapaw tribe without resources and with a scarred homeland. So Class 2 gaming is extremely important to us. It's actually the economic tool that's getting us out of poverty and beginning to provide some economic stability in a county that has seen, since the closing of several plants and the listing of Tar Creek Superfund as Superfund site as the #1 site on the national priority list for EPA, we've steadily gone downhill. But in 1982, the Quapaw tribe began its bingo, and with Class 2 gaming, we have turned that economic disaster around with the other tribes, the other 7 tribes that we share Ottawa County with. And if it wasn't for Class 2 gaming, I would not be here today. I would probably not have gone to college. My children probably would not have the opportunity to go to college. And we would probably still be trying to eke out a living out of a place that's horribly scarred. So we have a big stake in the Class 2 world, and we have a long history in Oklahoma in Class 2. And for part of my testimony, I'm going to provide the written testimony that I provided the Natural Resource Committee in February 20th of 2008, and I'm going to read some of it because I think it holds true even today. Class 2 gaming has been the backbone of gaming activities here in Oklahoma, and it remains critically important to all of us. Over the years, the Oklahoma tribal leadership has played a leadership role in defending Class 2 gaming technology and ensuring tribal governments are accorded the full benefit of the Indian Gaming Regulatory Act. After a decade of litigation, the tribal views in relation to the legitimacy of electronic aided Class 2 gaming were vindicated by not less than 4 federal circuit courts, defeating time and again the government's theory that IGRA limits Class 2 gaming to the game of bingo as played by children. In fact, the circuit court holds in these cases are so closely aligned that the Supreme Court refused to grant the government's petition for review in March 2004. Thus, we thought at the time, bringing closure to a long period of debate and conflict in clarifying the legitimacy of electronic aided Class 2 gaming. And then in another paragraph, which I will submit this, one need not to be an expert to understand the implications of losses of this magnitude. And I'm talking about the losses that would be suffered by tribes that depend on Class 2 gaming. Yet more is at stake than the bottom line. Class 2 gaming is within the exclusive authority of tribal governments and may be offered independently of tribal state gaming compacts. While we are pleased that we are able to work out a Class 3 compact with the state of Oklahoma, there was a time when our requests to enter into compact negotiations were rebuffed. Were it not for Class 2 gaming, Oklahoma tribes would still be mired in poverty with little hope of change. We would still be largely dependent on federal aid for essential tribal government programs and services. Many, if not most of our children, would not continue to find the doors of higher education firmly shut. And we would not stand before the committee today with the kind of optimism and excitement we have now about our future. So I want to talk a little bit about where we've come today. We've had a small casino that has, I think, 680 machines that started from our 1982 bingo hall. But last year, the Quapaw tribe decided that we wanted to reach higher and dream larger. And with the help of some very fine people, we developed the Downstream Casino Resort, which is a $301 million full-service resort casino with 2,000 slot machines, 222 rooms, 6 restaurants. We're the largest employer in Ottawa County. We're the 3rd largest employer in the region, only third to 2 hospitals. We are 100% managers of every part of our businesses. We don't have management contracts. We don't have licensing agreements. Everything that's under our roof is owned and controlled by the Quapaw tribe. And we have what we think is one of the best regulatory agencies in Oklahoma for tribal governments. And We think that's very important for the integrity of the game, and we have a great relationship with our Tribal Gaming Authority. So if it wasn't for the Class II gaming and what it has brought to us, we wouldn't today be the largest employer and be going down that road of self-determination. That was the reason that the Indian Gaming Regulatory Act was first designed. I believe that Chairman Hogan's problems are in his process, and I think that's where it really bothers me. And I think it was typical of the Bush administration that they developed a process that was anti-government to government relation, and it wasn't respectful to the sovereignty of tribal governments. Even though President Bush appointed me till 2012, I think that might have been one of his only good decisions. I think that the institution of the Bush government, which Chairman Hogan was very much a part of, was very much about keeping tribes down and not recognizing their sovereign authority. And at every step of the way that they could, they would try to chip away at that sovereignty. And I think it's clear, and if you look across the board, whether it's within the Indian Health Service or the Department of Commerce or within the Department of the Interior. And I think that in retrospect, it's shameful how they used a corrupt process that really isn't that difficult if you engage in a government-to-government relationship, but they decided to not go that path and create sort of like I said, a corrupt process that wasn't respectful to tribal governments, tribal sovereignty, and the rule of law. And I like J.R. Matthews, look forward to the day that Chairman Hogan goes back to South Dakota and retires, because I think he's damaged the relationship between the federal government and tribal governments in a way that needs to be healed. So that's my testimony, and I'll stick to it.
Okay. Thank you, Chairman Barry. This completes the testimony part of the panel, but we have set aside 45 minutes for questions and discussion. Mr. Foreman, do you have any questions on this panel?
I don't.
Okay, Mr. Berlandra, I'll turn it over to you.
Thank you. I do have a few questions, and then I'll look around and ask others if they do too. Chairman Steele, thanks for being here today.
Yeah, thank you.
I happen to be the Chief of Staff at the National Indian Gaming Commission at the end of 2006 when you were going through your transition from Class 3 to Class 2, and some of the difficulties that the state of Montana didn't quite understand what they what was happening to them, I think. And that's where my first question is for Chairman Steele, about if you would describe in a little more detail. I think it's very instructive how you went about not only reclaiming or taking control of Class 2, but really reclaiming jurisdiction over all of gaming within the boundaries of your reservation. If you tell us more about that, I think that'd be
Madam Chair, Joe Valandra, the process, we sat down and very strategically thought about what we wanted. Our Class 3 proposal with the state of Montana proposed that we would allow for the current operations of all the gaming on the reservation as is. But all of those operations on our reservation need to come under tribal jurisdiction. They needed to come under our regulatory authority. They could operate, non-Indian operators could still operate. The mom and pops on our reservation could still have their bars and their machines. But they would be capped at the $800. Well, actually, we lumped them all in with our proposal. That it would be, we determined the amount of payout in what I iterated earlier. That was our proposal, and we laid it down to the state. And I don't know what it's like negotiating with other states, but negotiating with the state of Montana, you might as well just be by yourself and negotiate against yourself, because that's what we were doing. Put our proposal on the table, well, that's not good enough. Throw back at us, and okay, well, we talk amongst ourselves and throw back at them. No, that's not good enough. You know, and then the other idea, the governor came and campaigned on a new day in Montana. You know, I'm here from the state government and I'm here to help you, kind of a thing. And came and said, you know, I believe in government to government relationships. And if I have issues with you, I will sit down with you across from you at the table in your tribal headquarters and negotiate with you. Okay, well, that sounded like a pretty cool deal. But when it came to Class 3 gaming, you know, okay, we would like to see the governor face to face. Well, no, I've got my negotiating team. They negotiate for me. Oh, what, you know, so that was, that whole year of 2006 went along that way until the 11th hour. And that's when the governor showed up and all that. But the intent was, one, we were going to recognize all existing gaming on a reservation, but it had to come under tribal jurisdiction. Of course, the state said no. The operators on our reservation, the state-regulated operators, we didn't feel like it was our responsibility to inform them as to what was going on, but we did our best to inform our individual tribal-regulated operators. So let me paint this real quick. You had state-regulated operators, you had tribal-regulated operators, and then you had the tribal business Class 3 operation. So you had a wide variety of different gaming activity on our reservation. In my opinion, it occurred that way because it really wasn't, it was kind of an afterthought when IGRA got approved, and then we ended up with a fight with the state of Montana, and all the Class 3 gaming ceased on our reservation for a number of years back in the 90s. It really wasn't the primary thing after IGRA, because we had our plans made in Polson there to make it a casino resort, and then IGRA hit. We had machines sitting right there ready to plug in and get going, and IGRA hit, and well, we didn't get to turn on the machines. So, but essentially, I hope I've answered your question, but
Well, you've given us a more of the factual background, but I think what I'm interested in is, and I didn't ask the question this way, so I'll ask it this way
Okay.
now. What impact taking over or asserting your jurisdiction over all of the gaming within your tribal boundaries, what impact has that had both to your regulators, to your state government, and to the people who live within those boundaries?
the tribal government side, it's increased our income, our tribal dollar income. I think it's doubled it from 2 to about 4 million approximately, which is not a lot for a lot of tribes, but in our diversification, it's significant. The other important thing is it's brought nearly 160 to 200 tribal member jobs that we didn't have before. The other thing is all those mom and pop, non-tribal regulated, state regulated operations on a reservation no longer have Class 3, no longer have any form of gaming. Some of them have gone out of business. Some of them have gotten creative and, figured out how to. One quick thing, the state of Montana has joined Class 3 gaming with a liquor license. So you can't have Class 3 without a liquor license. So all the mom and pop bars on our reservation that no longer have Class 3, it made it adversarial with the tribes. It's the tribe's fault I'm out of business. I think economically it's added to the tribe's income. Tribal member-wise, it's added, nearly 160 to 200 more tribal jobs that we haven't had before. Regulatory-wise, I'm not a regulator, but I think to having just 2 tribal casinos to regulate as opposed to, I think it was 10 individual tribal operators and 2 tribal casinos, it might be a little easier, but I'm not the authority to speak on the regulation aspect. But in my opinion, as a tribal leader, it's a much better situation. The other thing is I had some non-members on our just to clarify, on our reservation, there's 26,000 people approximately. We make up about 3,000 of that. We have 7,000 members. Half of them live off, half of them live on. So we're a minority on our own reservation. But I had just a few weeks ago, last week actually in D.C., one of the gentlemen that lives on our reservation who's a non-member, he said, you know, I'm wholeheartedly agreeing with there just being 2 locations on a reservation to gamble at instead of having a whole bunch of places. He said, I'm not in favor of gaming, but if there's going to be gaming, let's have it localized to 1 or 2 spots and not all over the place. So did I answer that question better?
Sure. I have one more question, then I'll hand it off. This is for both of you to answer in any way that you'd like. One of the purposes of IGRA was to create strong tribal governments, or to help create or help support strong tribal governments. Can you describe, and Chairman Slow, you started to, but how the regulation of Class 2 contributes to your tribal government, your tribal sovereignty?
Want me to?
Either of you.
Go
or
ahead
both of you.
first.
I'll finish off, I guess. My opinion is that the preeminent thing for us as tribes, and particularly the Salish Kootenai tribes, is that I'm always reminded by our great congressman from Michigan, Dale Kildee, that reminds us of the Commerce Clause. You know, tribes are mentioned right there in the Constitution. I think the ability to regulate our own gaming activities, our own reservation, it's part of being self-sufficient and self-governing, and it's part of sovereignty, in my opinion. The Salish Kootenai tribes are a 638 tribe, a self-governance tribe. We regulate or compact and run just about every single federal program that we have on the reservation, from law enforcement to our courts to our title plant, just a variety of things. And we had to fight, like a lot of us Indian tribes in the United States, but we had to fight on our own reservation with our own non-member community on our own reservation. But it's one more feather, I believe, in our cap to say, look, we can do it. And we can do it very professionally. We have tribal members that are educated that can do it, that are trained professionally. And in my opinion, it just adds one more thing to us that we are able to do. And we've proven ourselves. We have to prove ourselves every day in the greater society, but also on our own reservation at Flathead, i.e. the Bison Range, which this isn't a forum about that, thank God. But, you know, I guess that's my best answer for that.
Would you repeat the question?
My question was that one of the purposes of IGRA is to create or support strong tribal governments, and how does the regulation of Class 2 contribute to that objective?
You know, I think if you wanted to find one of the best case studies for how IGRA has helped tribes become more self-sufficient, you could go to Quapaw, truly. In the 7 years since I became chairman, we've had less than 100 employees. When I started to today, we have more than 2,000 employees. We are now the first responders for fire and EMS medical in our part of the county and into Missouri and Kansas. And we provided for Indians and non-Indians alike. We have gained somewhat better control through litigation using IGRA to help us in our environmental problems and the legacy that came from Tar Creek. So for us, it's been Class 2 gaming and it's been IGRA that's been the driving force that has brought us to where we are today. And without it, we wouldn't have been able to do any of the things that we do today. We now have methadone clinics for people that have suffered from the ravages of certain drugs. We have, a convenience store. We have fire departments, ambulance service. We have environmental departments. We're now a 638 tribe, a self-governance tribe. We have our own courts. We're about to start our own police force. There's nothing that we do today that hasn't been supported and driven by Class II gaming and by IGRA.
Any other questions?
Yes, if I might. Welcome to both of you to California, and to you, Chairman Steele. Your reputation precedes you. Believe me, sir, we've heard a lot about you. Are you prepared to talk in general terms regarding, I understand that the preponderance of the Class II games that currently are being operated by your facility are of the one-touch genre. Do you have information that you could share with the commission regarding the revenue performance of these Class II devices versus the video lottery terminals whose use is now, the cessation of whose use has occurred as a result of the dynamics that you described in your testimony? Is there a big difference between the revenue the VLTs were generating and these one-touch Class II games that you're currently operating?
Madam Chair, Mr. Lombardi, are you meaning the VLTs are the two-touch, or?
The ones that the state was operating that are no longer being operated in the reservation versus the one-touch games that you...
Okay, Madam Chair, Mr. Lombardi, the Class 3 machines that we had on the reservation, in terms of, let me restate if I'm understanding the question correctly, are we making more money per machine as opposed to?
That's really what I'm trying to figure out.
Okay. In my opinion, I think if we had Class 3, we'd probably make more.
Okay.
Because the people in Montana are used to the particular type of machines that are there. But, and that's hypothetical. I can't really put my finger on it.
It's a hypothetical question,
Yeah,
Chairman.
but I think if we could have our proposed compact, I think it would potentially make more money than under Class 2.
Okay.
But the thing is, the other thing you have to think about Montana, it's the fourth largest state geographically, but it's only got 900,000 people, and you drive, it's nearly not as big as California, but it's still big in terms of eastern United States. But, we just don't have a lot of population, so, but we are in the population corridor that seems to be growing between Missoula, Montana, and Kalispell, which is a major tourist area from Yellowstone Park to Glacier National Park. And so I think that would be the best way I could answer that.
You've answered your question.
Okay.
Thank you. My last question, the role of your Tribal Gaming Commission in the determination of the status of these devices as being Class 2 and the licensing of the vendors, are you prepared to talk a little bit about that?
I can talk a little bit about it, and if I can't answer it, I'll just say I can't answer it. But I guess from what my understanding is that, they follow the regulations that are pretty much there with the NIGC. Then really the only licensing that they have to do is the two resort facilities that we have, one on the southern end of the reservation, one in Polson near Flathead Lake. And, other than that, I wouldn't be able to get into much detail because I really don't, personally I make it an issue not to really get into a lot of that. But I feel confident that they have complied with what they need to comply with. I do know that when, this is a sidebar, Madam Chair, for just a second, I do know when the challenge came up with CRIT and NIGC trying to exercise authority over Class 3, they came, when we were in negotiation, but we still had a Class 3 compact, and we had members of the NIGC staff come to our reservation and want to, pardon my language, but stick their noses into something that was none of their business. And so we told them, no, you're not welcome. We're not going to share that information with you. Chairman Hogan was at a hearing at that time, and he made a big comment saying, well, there was a tribe in Montana that slammed the door in the faces of some of our regulators. Oh, we didn't really slam the door in their faces, but in hindsight, if it had the chance, I probably would have. But I'm sorry for diversion there, but that your question kind of brought up that thought. Yeah, well, I guess it just, I better be quiet. I'm gonna divert way off a rabbit trail. So, thank you, Madam Chair and Mr. Lombardi.
Chairman Steele, how close is the closest NIGC regional office to your reservation capital?
If I remember right, I think it's in Minneapolis.
So unlike the rest of us, it's not a 30-minute trip for them to come visit you.
No, it is a significant, it's a 2-hour flight from Minneapolis, 2.5-hour flight from Minneapolis to Missoula, and then it's 40 minutes from there up to Pueblo where they came to talk to us. So,
How many visits a year do you have to endure?
well, after we filed our lawsuit in the DC circuit, challenging the process, I think we had a few more, but I'd have to go back and check my records. But all in all, outside of our fight on the Class 3 issue with them trying to stick their nose in it, and then our fight with the state, it's been fairly an amiable, relationship. We did have some issues. We really had, where we had our problems internally was we went from Class 3, then we threw in Class 2, and we were all looking at it like a calf looks at a new gate. We just really didn't know internally how to handle that, and so we had some issues. We had some findings, but we addressed them with the NIGC. They worked with us, and so in that respect, I think they were helpful. I think they could have helped us a little more on the technical side of it, but
But my point is that we're looking at probably 3-4 visits a year most years.
I think that's probably what we have, But like I said, I think it was a little more after we filed that decision, our FACA court case with Santa Rosa. And I think Santa Rosa, I won't speak for them, but I think they had a similar thing. Well, Crit, I think, did too. The Colorado River Indian tribes, I think they had, a few more rocks being turned over and everything else by the NIGC, which I won't add anymore. I just think it's Madam Chair, if I might, I just think it's personally a travesty of justice that we pay those Chairman Hogan's and whomever else's pay. All of us, Sycuan and Flathead and all of us contribute to pay their salaries. And they come back with these kind of decisions and these kind of things and make these comments like, well, this is not a democracy. Those kind of things. And I just, I'm going to leave it at that. I just think it's a disservice, and I really agree with my colleague here, the chairman, that I think they've done a lot to damage that government-to-government relationship in terms of gaming, and especially on the Class 2 and Class 3 issues. And I was in D.C. last week and visited with one of President Obama's staff people and encouraged him. I said, if you can't get him to be fired or what have you, just tell him to pack his bags and wait till the next person comes to town. And that's what I told him. You got me on a rough subject, so I
Chairman Barry, would it be fair to say that they come and visit the Quapaws a lot more often than they do the tribes in Montana?
I think that they like to eat there, I think, because we see them, I think, on a daily basis. And, you know, I think we're fortunate that we have a strong regulatory office, and they always interact with the NIGC. So it's rare that it bubbles up to the tribal government, but I know that they're in our facilities on a regular basis.
Thank you, Chairman Still and Chairman Barry, for your presentation and discussion. We're going to take a 15-minute break now. We'll reconvene at 3:15.